What's up?
Okay.
Your Honor, I'm going to start and I'm going to give it my...
Well, let me call it to order here.
Well, we don't here.
We'll let you get going here. Let me call to order the Town of Loxahatchee Grove Special Magistrate hearings. Today's Wednesday, March 6th. It's about 2 o'clock, and we're here. Looks like we rescheduled case number 2012-311, which is 1930 D Road LLC, being the property owner. And everybody ready to proceed? You had a comment there. Why don't you tell me who you are so we have it in the record?
I'm Pat Hastings.
Your Honor, should we be sworn in first?
Yeah, we will do that. I don't think this is the nature of testimony, or is it?
Well, we're not going to lie.
Well, no. Well, I'm going to swear everybody in, but I didn't know if you had just something preliminarily.
No, yeah, I'm just going to do it. I just wanted to see if you remembered me from last year. My husband was with me. We had to move this same renter that we have from 162nd Street, where we had 5 acres. And actually, I think you viewed a video that Seth had brought between last time and now, maybe. At the time, we were not notified that had he been there since before October 1st of 2006, he would have been grandfathered in. So everything that we had to do last year, we should have never had to do because he had been there since prior to the October 1st of 2006. I can find the lease, but it's in storage in a container at the nursery, and I have to go look for that. But I wanted to just see if I could jog your memory a little bit.
Well, remember your case generally, and why don't we just begin then?
Well, I just want to remind you that when we ended the case and everything was settled, I can remember you saying, and it's okay for them to go to this property, the 10 acres on A Road. And everything was agreed to.
Well, I don't know that I would say that. Maybe I said it, but
Well,
I don't know why. I don't know why I would say that.
Well, you were asking the code enforcement people
Oh.
if they were happy that everything was done and that we'd moved to A Road and we'd had a couple of extensions, and yes. And now I'm just going to turn it over to Jerry because.
Okay. Well, the town goes first anyway.
Ah.
So I'm going to let them go, and then of course you'll have your chance to present whatever you want to. So why don't we let me swear the witnesses now. Whoever's going to testify, either you're going to testify. Do you swear the testimony you'll give will be the truth, the whole truth, nothing but the truth?
Yes.
Okay, let me hear from the town.
Thank you, Your Honor. This is case 2012-311, Town of Loxahatchee Grove, Florida. The petitioner versus 1930 D Road LLC, represented here today by Mr. and Mrs. Hastings. The property control number is 41-41-43-17-01. 115-0010, property location at 2374 A Road. Your Honor, I have prepared and will submit to you exhibit number 1 as part of the presentation.
Okay, have you seen what they have? This is
No.
this is the affidavit of complaint, it's called. You haven't seen it?
Possibly, we don't know.
While they're looking at that, may I proceed?
Sure. Well, let's let them look at it in a moment so
Okay.
so they have a chance to listen and read.
No, we haven't seen this. We see this was filed 6 months ago, and it stated that the person was going out of business. He's still there today, so maybe that might be the first thing. Going out of business, I suppose we're all going out of business at some point. 6 months is, I would argue, that it wasn't enough.
Okay. And your name, sir, is?
Jerry Hastings.
Is that with the J?
It is.
This is our taxes are not delinquent either.
But really the point of your, I want to give you a chance to read it, but most of all, I need to know whether you object to the exhibit.
Absolutely.
What is your objection?
First of all, our taxes are paid up, I think, except for 2011.
Well, you'll have a chance to correct
But-
it.
I would take great offense with the spirit of the offense.
Let me get that thing.
Mr. Ryan, I haven't had a chance to examine it other than he was afraid that there was going to be a mess left on the property. I've owned 15 properties in Loxahatchee Groves over the last 20 years. Every one of them is in much better shape right now than it was the day I bought it.
Well, you're getting beyond the...
No, I don't think so, sir. His
Well, I think,
complaint.
wait a minute, I think you are, because all we're doing is getting this exhibit into evidence. You're gonna have a chance to present your case. We're gonna give you a
Well, we've
chance.
never seen that, and the man is not going out of business, and that's an absolutely ridiculous statement.
We're to come here to make an argument on a complaint that we're just now being shown.
Well, this is a complaint. There's gonna be, I'm sure the town has served you with a notice of violation.
Yes.
That is gonna be the basis, that's not this document, right?
No, why didn't we get that document?
If I may move on, I have.
Yeah, let's move on. I will admit this into evidence for what it's worth. I'm gonna let you comment on it, and if you think it's incorrect, you certainly can correct it. And I
Why
will
weren't we
listen to
given that
Let
before?
me ask you this, is the basis of everything that's coming because of this complaint?
I can't answer that. I'm gonna admit this into evidence, so let's move on.
All right, thank you, Your Honor. And just as a point of clarification, the property appraiser and the tax data that is presented here is not subject to this hearing. That we have to provide this in terms of property ownership, and that's the justification for the property ownership. Your taxes are not in question. Moving on with the actual complaint. The affidavit of complaint was filed on October 18, 2012. There was some concern when the complaint was filed regarding unmanaged landscape waste and debris that had been located on site. The concern also culminated into some potential concern regarding that unmanaged waste and debris becoming a fire hazard, if not already a fire hazard. So you'll find that that was primarily the reason for the affidavit of complaint. As you will find here, we have verified, Your Honor, that the property is actually owned by 1930 D Road LLC through the attached property appraiser and tax collector information. Upon the town receiving the affidavit of complaint on 10/18/12, there were a series of activity, and certainly Russ is here, and I can certainly defer back to Russ, but just as a summary, we made numerous attempts to meet with Mr. and Mrs. Hastings to discuss this potential conflict and the allegation. On 11/1/2012, a site visit was set up by Mr. Elgin to meet with the Hastings. It was a no-show on the property. On 11/20/2012, a site visit and a meeting was again rescheduled. It was canceled by Mr. Hastings, but rescheduled again for October 26th of 2012. On November 26th of 2012, there actually was a meeting with Mrs. Hastings regarding submission of a special exception application, which would have perhaps resolved the situation. The deadline that was imposed upon Mr. and Mrs. Hastings was a deadline for submission of that application on December 14th of 2012. As of December 26, 2012, nothing had been submitted, and as a result, it ended in the notice of violation. Again, you'll have a chance for rebuttal. It resulted in a notice of violation being issued on December 26 of 2012, and I present to you Exhibit 2, the notice of violation, site photos, and the affidavit of service.
Okay, now have you seen this?
No.
have a chance to look at it, Your Honor, I'll go into the violation.
Any objection to this document?
My objection is, I'm saying it right now for the first time, and that it's very hard to argue something with 2 minutes notice.
Well, I'm sure this was served on you.
No, we never saw the pictures. The violation was, yes.
Well, I will admit the document. You're going to have, I'm going to give you a chance to respond to that. But I will admit the notice of violation and photographs. And we'll have probably Mr. Elgin testify to the photographs as well, and you can ask him questions about them. If you think the photographs don't accurately depict the property, certainly you have a right to present your own or to question how they were taken, why they were taken, where they were taken, when they were taken, those sorts of things. Okay. So I will admit the exhibit 2 and let the town continue.
Thank you, Your Honor. As on December 26th of 2012, Mr. Elgin did conduct a site re-inspection. At that time, he did identify the fact that the property was being used for chipping and mulching, a commercial chipping and mulching operation without a special approval that would be required for that type of activity. The reference code for that alleged violation is the Loxahatchee Groves Unified Land Development Code, Article 20, Residential Zoning District, Section 20-015, Permitted Uses. You'll find that in Section 20-015, Permitted Uses, commercial chipping and mulching operations are specifically permitted subject to Article 80. It does not mean that they cannot, but it is not a permitted use. It is a permitted use with conditions. We have the corrective action that was recommended to the property owners was that they obtain or they submit the application for commercial chipping and mulching operations as it related specifically to Article 80-055 of the Unified Land Development Code, which specifically address in that section commercial chipping and mulching operations. As a result of that inspection, the town moved forward, and you'll find in the exhibit that the notice of violation was issued on the same date, December 26, 2012. Compliance was to be sought by January 11th of 2013. We did provide service of that notice to the property owners. You'll find in that exhibit the service that was provided through certified mail on 12/26 of 2012. I'd also refer you to the photographs, and again, Mr. Elgin certainly can attest to this. And then I have photographs in the subsequent exhibit as well. That in this particular case, the debris that was stockpiled on this site was being brought onto the site from other sources, and that it was not an ancillary use of any type of commercial or any type of activity that was occurring on site.
When you, let me just ask you, when you say debris, do you mean wood that's being chipped?
It had not been chipped, it was undermined.
But it was brought, you were saying wood was being brought in.
It was being brought in for the chipping and mulching operation. If I may continue on, you'll find in Exhibit 3.
Objection, Exhibit 3.
Same thing.
Same thing, being not enough notice.
Yeah, so, give us,
Okay, well, there's a notice of hearing, which I'm sure was served on you, or was it? Did you receive the notice of hearing?
Yes.
yeah, I'm just looking at the pictures and,
Okay, so again, the photographs.
yeah. So they can always be angled in a certain direction.
Okay, well, certainly what you asked about those. So I will admit Exhibit 3 into evidence.
May I see Barbara?
Sure.
Thank you. The property owners were, Exhibit 3 demonstrates that we did notice pursuant to state statute, the notice of hearing for the order of violation today. Attached to that is the actual notice, plus the affidavit of service. They were served, they're certified mail and property posting. Those photographs showing property posting are also attached as part of Exhibit 3. And I'd also like, those photographs also demonstrate again where there is activity of debris being hauled on the site from on-site and being stockpiled for the shipping and mulching operation. Also, if I may, attach to Exhibit 3, there's also a letter in there. This letter was to Mr. and Mrs. Hastings. It is a letter from Mark Cutney, the town manager. It was emailed and dated to the Hastings on 12/6/11, where they had in fact requested a zoning confirmation letter for the property. What you find in that exhibit is the response to the zoning confirmation, where again it just reiterates the compliance for this type of operation pursuant to Section 80-055 of the Unified Land Development Code. I'm also going to provide Exhibit 4.
Let me just ask a question about that letter. Is it, do you have a date on when it was sent?
Yes, sir, I do, and I did bring you a copy of it. So you can see where the email did actually occur. I apologize, Your Honor, I thought I had it attached to my exhibit.
Council meeting is until late March, so. Right. That's a good question.
Sorry for the delay.
It's one of the something stating
Well, I'm not sure it's crucial. I'm just curious
no,
where it fit in the chronology here.
I
But the
found-
letter was written by Mr. Cutney?
And I found it, Your Honor.
Okay.
I got it, and I will go ahead and submit this to you. I will submit it to you as Exhibit 4. Your Honor, I don't think I want to, I withdraw that.
Why don't we just move on?
Yes.
I have it here, and maybe testimony will pick up when it was, but this.
And what I will do, Your Honor, is when we have testimony from the Hastings. Do you have the email? That's what I'm looking for. Thank you.
What was the date of that?
It's dated December 6, 2011.
Okay, so the email was sent December 6th, 2012.
December 6, 2000. It was sent in 2011.
Okay, so it's,
And I'm going to provide that to you as Exhibit 4. Exhibit 4 will be the cover email transmittal to the letter of zoning confirmation provided in Exhibit number 3.
do you want to see this? Oops. Need to get closer.
I'm sure it's the same one that we got a year ago that they said we complied to, so.
Can I ask a question about this?
Sure.
This is December 2011. Is that correct?
That doesn't pertain to this case, that pertains to moving on
Is
to the other
that,
property.
is it customary to wait a year to act on something?
I haven't been sworn, I'm sorry, no.
Yeah, let me swear you in. Do you swear testimony you're going to give me the truth, the whole truth, nothing but the truth?
The reason it was sent at that time was that was a direct request of yours for a zoning interpretation as you were getting ready to move to the A property.
So, right,
At that point in time, how long had these conditions been in effect?
They've been in effect as long as I know.
So certainly before 2010.
Probably with the adoption of the LDC, the original adoption of the LDC.
Certainly before September 27th, 2010.
I don't know the date, it was 2009, I'm not sure the date of the LDC was.
Okay.
The ULDC was adopted, I believe, in 2009.
Yeah.
Certainly before September 27th, 2010. Thank you.
Okay, I will admit the cover email as exhibit.
Okay, and then the last exhibit that I have, Your Honor, is exhibit number 5. And I'll pass 2 down so that they can see a copy of it.
Those conditions, those UDC conditions, are they here in this room?
They were attached to the letter that was sent. If I'm understanding, you're talking about the section 80.80-055 conditions, right? And there's 10 of them you referenced in the letter.
They are attached, yes.
That was attached to the email and letter.
Okay, I have a copy.
Okay, I'm sorry to get off track here again.
I'm just labeling, Your Honor, the exhibit number here real quick. This will be exhibit number 5. Series of photographs that were taken as of yesterday, March 5th, 2013, again demonstrating non-compliance with the violation, non-compliance with, again, with Article 20, Residential Zoning Districts, Section 20-015, and non-compliance with Article 80-055 as it relates specifically to special exception approval for commercial mulching operations. And that will be the end of my presentation. I would like to reserve the right to rebuttal.
Okay. And what else, before we move on, any objection to composite exhibit 5?
No.
Okay. If there is no objection, they will be admitted as Town's Exhibit 5. Okay. Was there anything else from the town side that you want to present?
Not at this point, no, I will refrain at this point, and just like I say, I mentioned reserve right to rebuttal.
Okay, let me ask a few questions just so I can make sure I understand. The notice violation is a commercial chipping operation, chipping and mulching without a permit. Is there a definition in the code of commercial chipping and mulching?
I believe there is.
And maybe that's not an issue, but I just thought it would be good to know.
And if I may, I'm going to defer to Mr. Elgin, Code Enforcement Officer.
There it is. Chipping, the definition, taken straight out of any code. Chipping and mulching, the use of equipment designed to cut tree limbs, brush, or wood construction debris into small pieces, including the production and wholesale of mulch for land application.
Okay. And let me just ask you, as you've been out at the property,
Correct.
what did you observe as to the operation as it applies to that definition?
We have a number of machines out there processing anywhere from palm fronds to branches to any number of different kind of landscape debris. And if you examine the last set of pictures, you can see a representative description or of what's out there.
Could you read that description again?
Sure. Chipping and mulching, the use of equipment designed to cut tree limbs, brush, or wood construction debris into small pieces, including the production and wholesale mulch for land application.
Including the wholesale, sorry, the last few words there.
Including the production and wholesale of mulch for land application.
Can I ask a question?
Well, let me ask one more, and I'll let you ask whatever you want. So from your observation, that chipping and mulching is being taking place on this property?
Yes.
Okay, good, ask.
Okay, in that description, does it say anywhere about the making of soil?
It's the production of mulch for land application, so what you're going to apply to the ground.
No, I'm not asking what I'm applying. I'm asking, anywhere in there, does it say soil?
I just read you the description.
Okay, and it says mulch for land application, does not? Mulch is a wood product. Did you see mulch there, or did you see the end product as soil there?
I saw the processed material that was made from tree limbs, branches.
We agree that there's tree limbs there, we agree that there's branches there, palm fronds there, we agree that at some point it becomes mulch, but did you see the end product, did you see piles of soil there?
I saw piles of processed debris.
Did those processed piles of debris end, was the final stage soil?
I saw processed debris.
Did you see soil on the property?
I saw
Did you see
processed
piles-
debris derived
see
from
piles of
the
soil?
operations from the material that is being brought onto the property.
Can I be as vague as this, sir?
What I understand what your question, asking him,
Soil and mulch are two totally different.
I understand. Let me ask this, and then I'll let you follow up. Is there a definition of mulch in the code?
No,
Is there a definition of soil?
I'm checking.
By definition, we're not making, this doesn't pertain to us.
Do you have a soil amendment in your code? I believe you do.
Yeah.
Is there a way to print up the definition of shipping and mulching?
I can probably work that out.
I just think it might be good to look at, but, do you have any more questions?
When I get asked questions, can I be as vague as they're being?
Excuse me, I'll print out the definition for you.
Well, before you leave, do you have any more questions for Mr. Elby?
I will have before the day's over.
And don't disappear forever.
Well, he isn't, but we're gonna go in an order here where you want, if you have questions for him, ask him questions.
Okay, you want me to do that now?
Yes?
Okay, because I need to set a timeline. My first question would be, do you remember meeting with me and the renter in December of 2012 at the property, going over a copy of the application, which we had already submitted, which Ms. Tu had filled out for us months before? You went over each, ticked off each one, said, yes, all this will work, we want to work with you. And then going with the renter and asking him to start the machine so you could check the noise level, and stating that the complaint that you were out there for was the neighbor to the north, the fish farm to the north, Michael Breen. And today is the first day that we've ever been privy to anything other than Mr. Ryan being here at the last hearing and saying that he was going to be part of the case. This is the first that we've been aware that Mr. Ryan had made a complaint. Do you remember that meeting and saying, we want to work with you? Do you remember that?
Correct. We did.
So you remember and acknowledge that meeting?
We met on, I believe it was November 26th, and that provided, actually, you took, received the papers. We met with yourself and Nick Siafi, and I gave you 2 applications and copies of codes and some requirements, and these are what you have to comply with.
Okay, those requirements, those are the 10 things that you presented a few minutes ago?
Mm-hmm.
Okay. We feel that every time we meet with the Code Enforcement Division of Loxahatchee Grove, the rules change. We feel every time we meet with them, they make it tougher on us. They make it tougher for a small businessman to stay in business in Loxahatchee.
I'm going to let you testify,
Okay, well,
but now's the time to ask questions.
okay.
We're not attorneys.
I want to ask,
I understand that.
so I get a better understanding of exactly what's happening here. Are you a special magistrate? Are you an employee of the town of Loxahatchee Groves, a subcontractor? Exactly what is the, how are you employed by the town?
I am not an employee of the town. I am hired by the town as far as rendering these services.
So that's similar to the, if we had submitted an application and paid a fee, it's sort of subcontracted the same way that would be? I'm just trying to get an understanding of the process.
I'm not sure how that would be the same, but I'm hired by the town council.
Okay. The reason I wanted to bring that up is it seems like they make it more difficult for us. They gave us the 10 things here, or the UDC code, or whatever it is. But the first time we had contact with them was September 27th, 2010. We got a letter, a courtesy notice of violation. And in that letter, it outlines, dear property owner, and then it outlines the conditions for chipping and mulching. And the first condition is minimum lot size, 5 acres. Now, we agreed a few minutes ago that this was certainly way before September 27, 2010, but right here from the town, 2010, is the conditions. I've marked this one 8.
Your Honor, yeah, you're testifying, and
Yeah,
we also have the complaint in here too that I believe it wishes to speak.
Well, this,
Yeah, again, this is more your side of the case, and you're going to get to present it. So you need to ask questions.
My question is, can you explain this? You don't let us get, you didn't mention to us when you came out with the complaint that, hey, if you were here before October 1st, 2006, you're grandfathered in, but the guy up on the corner can do his 2 acres and stockpile asphalt, and he's grandfathered in. You don't mention to us, isn't that what your responsibility to say, hey, if you were here before 2006, you're grandfathered in?
We should have never been made to move a year ago.
Mr. and Mrs. Hastings, again, the way this will work is that there is a process and a procedure. You will have the opportunity to testify. Excuse me, sir.
He's asking
I
the
want
question.
to hear your testimony, and then so that we have an opportunity for rebuttal.
Yeah, but again, questions. I don't know if that was a question.
Well, the
The question was, can you explain why we've got this is your first notice to us, you gotta have a minimum of 5 acres. And then once you start finding us and forcing us to move, you gotta have 10 acres. We certainly agreed that these conditions were in effect before.
Well, that's a good question. Let me ask, has the code changed from 5 to 10 acres?
We agreed 4 times. I asked the same question. Certainly it would have been in effect before September 20. I gave the exact date, and they all agreed that yes, it was 2009 at the earliest, at the latest.
This other county.
Yeah.
And this isn't for this case.
Oh, but this case was because of the other case.
If it's not the kind, why did we get the letter and the statement if it's not for this case?
Mr. Magistrate, this is not even for this case.
Oh, my God.
No, it's for the case that you set us up for this case. It's the case before that you forced us out of when we should have been grandfathered in.
And we were on 5 acres then. He forced us to move.
Okay.
Yes, it is the county code. Yes.
Okay, so just so I understand where this comes from, this letter is concerning a different property, right?
Yes, sir.
And this letter was written at a time before the town adopted its ULDC.
Oh, I saw.
So it's, I'm just asking, I don't know. I'm asking.
We asked this question a few minutes ago. 4 times I said, so these conditions were certainly in effect on before September. I gave the exact date, September 27th, 2010. They all agreed 3 times. Yes, 2009 at the latest. I'm just making this point. They make it very ambiguous. They say they want to work with us. We don't see it at all. We see they want to force us out because our only thought is because we don't live in Loxahatchee. Things were great when we had 1 vote per acre that we owned for the water district. But since we don't live here, we get no say. We get to
We've only owned property out here.
play by
Since
their rules.
Okeechobee Road was a dirt road.
We've owned 15 properties. Every one of them is much. The subject property right here, when we bought this property, was 10 acres of hurricane-ravaged, 60-foot tall Australian pines fallen into fish farms. We spent over $100,000 to clear and level this property. And Mr. Ryan is concerned that maybe some mulch will be left there. It was a disaster when we bought the property. It was 10 acres of ravaged Australian pines fallen into fish.
Again, you're testifying. Do you have questions?
My question is, why did we get this letter saying you needed 5 acres? My question is, why didn't they bother to tell us we could be grandfathered in?
You can answer if you can.
I can certainly try to clarify. The Loxahatchee Groves Land Development Code was adopted November 16, 2010, was the adoption date.
What's up?
I do know, and I provided, on numerous occasions, there was a moratorium during the time in which the code was being adopted. It was Resolution 0900. And at that time, 09010 put everything, all code enforcement related matters on hold for the adoption of the code.
Okay.
If you were not already in the process for your zoning approvals, once the code was adopted in November 16, 2010, then all development-related activity would comply with the Lots and Edge Grove Unified Land Development Code and not the Palm Beach County Code.
So when was it adopted?
All right, I don't know.
November
Okay,
16,
what time do you give me home? About 10
2010.
o'clock? Okay.
So a few minutes ago, it certainly was by 2009. You were in error a few minutes ago, all three of you, when you said that those rules were in
I think
effect.
how I commented and replied is as of 2009, 09010, everything had gone, as a result of resolution 09010, everything had gone on hold. There was no development approval, no development review, no code enforcement action at that point in time to allow people who had violations in terms of code enforcement, who had violations on their property, to be able to come in and to conform to the code that was going to be adopted, or that was adopted on November 16th of 2010.
Did it occur to any of you that we should have been grandfathered in? Did it occur to any of you to mention that to us?
If you're not grandfathered.
We were there, Mike Siafi was on that property since before 2006. We were not aware that he could have been grandfathered in. It cost us thousands of dollars to move him to A Road, and it cost him thousands of dollars to move there. And now you're telling us we have to get him off that property too.
Mr. Magistrate, can I now ask them questions too, since
Let's try to get back to a procedure here. Any more questions for these folks?
For the day, or?
We're only going to be here one day, I hope.
Yeah.
Your Honor, we also, like I said, we're finished with our presentation, but I believe the complainant also would like to provide evidence for the record.
Okay, we'll let him speak. What I'm going to do, though, I'm going to make this letter that you gave me part of the record, so it's part of the record. I'll mark it as the owner's exhibit 1, being the letter written by the town of Waxahachie Groves dated September 27, 2010 to Patricia Hastings.
May I make a copy of that one more time?
I have a copy.
Oh, yeah.
Yeah, we'll get copies.
I have a copy.
Okay.
I'm not sure of the procedure here. I'm doing my best to follow you and ask questions, but I have to sometimes make a statement to ask the questions.
Well, I'll give you some leeway, but I mean, generally it's time to ask questions. When
Okay.
they're done and after Mr. Ryan speaks.
When was the first time any of us heard, the first time that any of you have let us know that this complaint was based on Mr. Ryan's complaint?
We were aware of that complaint.
No, that's not the question.
Well, would you restate your question, please?
When is the first time you've let us be aware that all of this is happening because of Mr. Ryan's complaint?
We actually made you aware of the violation.
No, that's not the question, ma'am.
Sir, the process and procedure that is employed by the town of Waxahachie Groves is that if there is an active complaint, our job is to investigate the complaint. We investigated the complaint. We found that the alleged violation provided by the complainant could in fact be true.
Okay,
He's going on-
the only way I can ask the next question is
That
to
is
make a
not part of
statement.
our,
That was his complaint, that they were going on a
and
business.
that's not part, we did not investigate whether or not Mr. Chiao.
The only way I can ask the next question is to make a statement.
Okay.
Okay. You made us aware at some point that the fish farmer next door, I believe it was the day after Thanksgiving, because the fish farmer had visitors in from out of town, and the machines were being run either Thanksgiving Day or the day before Thanksgiving. He took exception to that. There was a confrontation between the renter and the resident, the fish farmer next door, you made us aware of that complaint. You made us think that was the reason for all of this procedure. Is that not true? And did you ever, at any point, mention Mr. Ryan's complaint to us?
Mr. Hayes, yes, sir. We may not have mentioned Mr. Ryan's name
That's all.
personally. Excuse me, let me respond. Certainly it is public record, and you could have asked for that information, but we did begin to work with you. As soon as we received the affidavit of complaint, code enforcement started to work with you at that point. And again, if I can reiterate the dates that I already mentioned during my presentation, we started to make attempts to work with you as early as November 1st, 2012.
Okay, I'd like to ask a question. I'd like Ms. Tu to look at this and see if she recognizes the form and/or the handwriting.
I certainly recognize the form. This is not my handwriting.
What about the NAs?
The what?
Yeah.
The answers to all the questions that aren't answered because they were not appropriate and didn't need to be done.
The NA is not.
Certainly, I'm not going to say that, Mrs. Hastings, I do recall making every attempt to work with you, and I made every attempt to explain the application to you.
Oh, wait a minute.
And yes, I'm not going to deny that some of these may not be NAs that I put on here. I believe what I explained to you is that what you needed to do was then take this application,
Right?
submit it to the town,
Correct?
and have the town review the application.
Correct.
And they would, and when you submitted this, if there were NAs, to have the appropriate justifications and documentations, i.e. such as traffic and traffic studies.
Stop. You,
Ma'am,
I'm sorry.
Wait, it's not time to argue, it's time to ask
Just give
questions.
me an opportunity to finish. And then once this is submitted, the town would provide you with a sufficiency review. And in that sufficiency review, they were going, the town planner, not the town planner, would tell you, as long as provide you with the justifications and all the code requirements for submission of a fully complete and sufficient application. So with that being said, let me ask you, may I?
Well, why don't we not? Let's try to keep questions going this direction.
Yes, I am familiar, short answer is yes, I am familiar with this application. And yes, in fact, if I recall correctly, in the process of helping Mrs. Hastings, I may have put non-applicable in those situations where I thought that she might be able to justify non-submittal of that information.
So you knew we were leaving the 5-acre property, the renter was leaving the 5-acre property, going to the 10-acre property, and we were working on this application to get them into the 10-acre property.
That was my understanding, yes, sir.
Okay, I took that application, as you instructed me, straight to the town. I gave it to Steve. I told him, let me know if you need anything else. The next thing I heard from the town was 2 days before Thanksgiving, we have a problem on A Road. Now, when I met with Russ and Brandon within the last month, Russ pulls that out and says, well, your signature isn't even notarized. I handed that to Steve. I said, please let me know anything else I need to do. Nothing. Our renter's been on A Road for almost a year or a year. He has been there a year. And all of a sudden, you didn't have the application, you never got the application. Russ had to give new applications to Jerry. The application that I took from the 162nd Street, when we stood by my car and filled it out, that I handed to Steve, and not another word was said until November of this year, or last year. I don't understand how that just happened to slip by everybody, and now we have to pay the price for it.
Well, do you, I'm not supposed to ask.
Well, see, back then, I did not need an engineer. I did not need a survey. I did not need a site plan. I did not need to pay $5,000 for the town to hire somebody out to review everything. Now, this year, I need a new application
Yes, ma'am, you
because,
did.
excuse me.
Yeah, let the-
Yeah, you keep on smirking.
Yeah, you did.
Keep on smirking.
You'll have an opportunity for rebuttal.
When I was in there 2 or 3 weeks ago, I was told, oh, you never handed in the application. If I didn't hand it in, Russ, how did you have it? Because Jerry gave it to you for the third time on site.
In the testimony.
Yeah,
Again.
you're testifying. And secondly,
I'm disgusted, Your Honor. I mean, this is just, the lies and the cheating that goes on here is, and I don't know if it's against us personally. I don't know what's going on here, but that application was delivered the day she gave it to me to take straight to the town, and I did.
Let me
Exactly what I
ask some
told her.
questions. Were all three of you aware that we were forced off the 5-acre property, that we were moving to the 10-acre property? Was there anybody that had any doubt that the Brenner Siafi Landscaping was going to cease the operation at 162nd Street and move to the 10-acre property?
I'm going to answer your question, but I'm going to respond to the fact that you are not forced off the property. Your leasee was in violation of the zoning code and could no longer maintain that operation on that site as a result of law.
Okay, were you aware for whatever reason Siafi Landscaping moved off the 5-acre 162nd Street property, moved through the 161st Street over to A Road, about 0.8 of a mile away? Did any of you have any doubts that that happened as a fluid operation, that there was not a shutdown for months, that it happened all in a period of 2 or 3 weeks?
Obviously, we were very much aware of it in light of the fact that you have an application and that you are also made aware that you would need to submit that application and get zoning approvals for the continued operation of that business.
Okay, so it was shut down on 162nd Street. We were fined. It moved to A Road. Is it part of your job to just let that go on, or till somebody complains?
We are in response to that, we are reactive code enforcement. We are not proactive code enforcement. You were made aware that you needed to have a special exception approval on that property. We did not take any action on it until there was an affidavit of complaint filed. And as a result of us being reactive code enforcement, we investigated that complaint and found you to be in violation.
So if we move to another property right now, you won't do anything until there's a complaint?
I would make the same suggestion to you again that I made to you back then, and that is if you decide to move that operation to another site, make sure that you have the appropriate zoning in place, and if you don't, to file an application such as the one that I gave to you, and have it reviewed by the town staff and found to be sufficient and approved or denied.
But if we don't do all of that, if we move to another property, you will be reactive or proactive or whatever you said, and not do anything until a complaint is filed. Is that correct?
Pursuant to town council policy, I do not send code enforcement out to do proactive code enforcement in town of Loxahatchee Groves. We only react to affidavits of complaint.
Let me ask a question. So, because nobody has complained about any of the town councilmen or their families breaking the codes, they have not been forced to stop operations, of which could be exactly the same operation that our tenant's doing.
Are you asking me a question?
Yes.
I know it is.
And you're all very aware of
We
it.
are all here to discuss.
No,
this
I'm
particular
asking the
case,
question.
and I'm not
Are
looking
you
to discuss-
aware that town council members and their family members have businesses operating within the town of Loxahatchee Groves doing the exact same thing that you have us sitting here and the magistrate wasting his time and all of our time, but their town council members, so nobody's gonna touch them? Because they're gonna get touched.
This is a quasi-judicial hearing, and I'm not.
But are you aware of that?
I'm not privy to discuss any other case.
Oh. There is no case. I asked if you were aware that they're doing it.
It just seems like every time we have any contact, the rules get tougher.
Well, let me put into context what I'm here to do. I'm only, you know, you may think you're getting treated badly by the town, maybe you are, maybe you're not. All I'm authorized to do is to see whether there is a violation of the code as alleged by the town.
We would just like to be treated equally, and this, I'd like to start right here and show another example.
Well, again, I'm going to let you testify, but we're at the question time.
Okay, I need to make a statement to ask the next question. At some point, Pat met with, or sent an email.
I talked to Mark at his office.
Well,
I followed up with him.
okay. There was an exchange of emails here on December 28th. Pat mentioned that we understood that all the agricultural cases were being put off for the zoning infractions. Mark wrote back that he's tried to refrain from getting an email exchange, but then made a statement that I'll read the last sentence of it and then I'll let him look at it. Further, I did tell you that we were putting the ag cases on hold until we received the AGO opinion. I have no idea what that is. However, at the last town council meeting on December 4th, 2012, town council directed town management to move forward on that case. If that's the case, we're being singled out and treated unfairly and unlike all the other agricultural cases.
Okay, let me just make this part of the record so we have it. It's a couple of emails. One is from
Captain Mark.
maybe to and from Mr. Cudney and Hastings, not Hastings.
Mayor, you want me to respond?
Yeah, I think that was generally a question, so.
Yes, be happy to. Yes, that's absolutely correct. Pat and I have, Mrs. Hastings and I have exchanged a lot of emails, but in that particular email, prior to her sending that email, I indicated to her in another discussion in my office that our town attorney had recommended that we go for an AGO opinion related to structural issues as it related to 604, I think, .50. I further indicated to her that in an abundance of caution, the town attorney had recommended to town staff that any case that very closely touched on any agricultural issue whatsoever would be our best interest to stay all those until we receive the AGO opinion back from the Attorney General. When she sent me that, she was inquiring in that email, as I remember that I have in front of me, but as to why their case was being reviewed, and that was my response to her. During that December 4th meeting, town council had specifically addressed that case, brought it up, and asked that but directed us to move forward. And my point was, that was our direction. The cases were the attorney's recommendation put on hold as a result of the AGO opinion. It was not due to any order or whatever. And I believe town council has the right and the authority to direct staff to move on any or all of those cases. And that's exactly what happened.
I have the minutes of that meeting that you say that it happened. Can you show me where it happened?
You might not see that in the minutes, sir. The minutes are not a verbatim transcript.
Well, we know people that were there, and we don't believe that what you're stating is true, and the minutes show that it's not true.
Okay, next question.
Give the magistrate the minutes, because that goes with the town was not addressed to continue our case in that meeting, but the town did.
Okay, I will mark and I guess admit into evidence.
We feel that's just another third or fourth example of we're not getting the same treatment as the residents are out here.
I will mark this admitted evidence as
Okay. I'm going to ask this question, and as much as I don't want it to be true, I'm afraid it is. The reason I'm afraid it is because I got a call from from a person who I don't know, who took the time to find out who I was and call me about it. Sometime in mid-January, my wife met with Russ
And Brandon.
and Brandon at the town offices concerning this case. When she left, I haven't been there, but I understand that there's the cubicles and there's no top to the cubicles, so what you say there is very easily heard throughout the building. This person called me and said, "What did you do to tick off the town so bad?" And I said, "Well, nothing that I know of. We are in a dispute about a renter and whether he's allowed to grind vegetation on his property." So they're going to label it hearsay. Do you want to hear it, or do you just want to just...
Well, go ahead and continue.
Okay. Like I said, I want to believe this didn't happen. But since this person took the time to find out who I was and call me and tell me this, I'm afraid that it did happen. And by God, if it is hearsay, I think he knows what's coming, just the fact that he already pointed out it's hearsay. But after Pat left, Mark came out of his office and said to Russ,
Outside, took him outside.
"I want you to find out all the property she owns in Loxahatchee and go after her for code violations."
Now, again,
Now, if we aren't
again,
being-
your testifying, are you asking Mr. Cutney if he said that?
Yes, and I'm asking Russ if he...
Yeah.
I will say unequivocally, I did not say that. Question.
Do you have any idea why on this particular day that she was there, that somebody I don't know would take the time to find who she was, who I was, call me and make me aware of this?
Yes, I know all about it. That's why I said it's hearsay.
And Jerry went to
I
your
know who the
office.
person is, I know what the person's doing, sir. I know what it's all about.
You know her?
Yes, I do.
Who is she?
I'm not gonna
Do you
tell
know
you.
her? Oh, so you know her and you know what she's
Well, why do I
doing?
have to tell you?
Okay.
Did you acknowledge that it happened?
That what happened?
That you told Russ to come in to find out what other properties he owned. You know we have 888 farms.
I've never asked Russ to
Every
do
renter
that.
we've had on 888
I've
farms,
never
you're
asked,
forced to
for
leave
the
for
record,
5
I've
years.
never asked Russ to do that.
And I'm gonna put one final cinch on the record, is that, no ma'am, even Russ, we are reactive.
I didn't say Russ did it.
We are
It was what was said.
Ma'am, we are reactive code enforcement unless there is a complaint that comes in by anyone other than a public official. And once Hatchet Groves code enforcement, we would not go out and proactively search your properties and look for code enforcement violations.
Okay. Based on what your statement just now.
Please ask a question.
Okay, I am. When I was in the office with Russ and Brandon, and I mentioned a few other people that were doing chipping and mulching, I was told, and I was asked, did I want to fill out a complaint against them? Did you not ask me that with Brandon? Would you like to fill out a complaint against them? Now, is that proactive? Were you coming after me to get me to put in writing, and I told you, no, I will not put a fellow farmer out of business. I don't care what they're doing.
Okay, but let me just
But
respond.
the point is saying they don't look for problems, they don't look to get people to make complaints, but they've asked me flat out to make a complaint.
Well, they asked you if you wanted to make a complaint, and when they get a complaint, they investigate, as I understand it.
Right, but-
And until they do, they don't. So you didn't want to do it, so there was nothing to investigate. I mean, is that,
And Your Honor, I would say
In a nutshell?
that happens all the time. People come and complain to us about issues, and we have to ask them, are they willing to do an affidavit of complaint?
I
Otherwise,
wasn't
we can't do anything
complaining,
about it.
I wasn't complaining about what was going on. I was pointing out that, why is it always me? Why once a year do Hastings have to throw a renter off their property?
okay, let's go with questions again. Any more questions?
What somebody's doing with our farm. I mean, that's our closing statement.
Do you think we're making mulch or making soil on the property?
You're processing landscape debris, and I've seen the process remnants.
What is the final stage? It comes in there in bulk, it goes through a machine. What's the final outcome of the total process?
It's processed into a material, and that's the extent. It's chipped, it's mulched, it's ground, it's done whatever. It's processed and put out in a finer form.
What is the particle size that,
I don't know the particle size.
would you say that it's coin-sized debris, or?
I'm not going to comment on the size of the specific debris.
Well, so when you ask me questions that I don't want to answer, can I not
Mr.
comment?
Hastings, are you suggesting that the final product is not a chipping and mulching operation?
By definition, yes.
Then you will have an opportunity to testify with our rebuttal. So you will have an opportunity to testify.
Okay, so when we're done with our questions, we're gonna get to give you the
Yes,
final.
ma'am.
Yeah, you're gonna have a chance to testify.
Okay, well, we're not used to this, because
Why not?
That's
But
okay.
we're trying
we
to
get, we
direct
only
you.
get to do it once a year here. I'm sorry.
Okay, any other questions?
Yeah, Mr. Ryan, are you satisfied that the?
Well, Mr. Ryan hasn't testified.
Oh, okay, well, you.
You can ask me some more questions.
But if he does testify, you can ask him a
Right.
question.
The things I said about, Mr. Cutney seems to know who this person was that called me and has this agenda. Are you aware of that person? And
I am not
did you-
privy to any of those conversations, no, sir.
Can you think of any reason that somebody would call me with?
In that particular case, no, sir. Again, in light of the fact that we are reactive code enforcement and we only investigate complaints based upon an affidavit of complaint. There would be no reason for any public official to have made that comment.
The reason that I believed at the time, and when I heard it all happen, was that, again, you can hear over the walls, and at some point during our discussion, Russ said, well, you'll just have to take that up with the magistrate. And I said, well, I will do that, and I knew that Mark was in his office and was hearing everything we were saying. And I said, well, that's fine, and I'll bring an email where he stated all the other farm cases are on hold, and that it was said that our case should continue. And none of the 8 other cases are being continued, but ours is, but it was not in the minutes, it was not said there. And I said, I will bring that to the magistrate. And then this person said, within a few minutes after I left, that happened. It made perfect sense that it happened. Jerry went out there, he got there at 5 to 4. Brandon was there, and Jerry came out actually to see Russ, to confront him and ask him if it happened that very day. But everybody was gone except Brandon.
Anything else to ask?
Yeah, are you aware with the Glenner's planted trees on the property is going to have a tree farm there,
There is a tree farm.
and that we're applying for an agricultural exemption for the property so that since we don't seem to be able to work with the town, are going to try to work with the state.
I have heard rumors of this.
But there's 5 acres there now that's planted in trees, and I applied for the ag exemption last Friday, and the papers were signed off on, and they'll be coming out to inspect it. Mike Siafi is doing soil amendment for the 5-acre tree farm, which is part of the 10 acres. And we will be going with the Florida Right to Farm Act. And I have emails from Carol Foreman from Tallahassee, who is the state attorney for the Florida Right to Farm Act, who says we can bring in vegetation, we can have him on the property if he's there for soil, and as long as he's not selling the soil from that site.
I'll be more than happy to respond based upon your testimony.
Okay.
Done with your questions?
Unless something new comes up.
Did you want Mr. Ryan to testify, or were we gonna,
I believe that you would like to.
were you gonna say something, sir?
Yes, sir.
Why don't you move up here, maybe, so we, one, see you, and two, get you recorded.
Sure. I think I probably need to be sworn.
Okay, you weren't sworn in, let me swear you in. Do you swear the testimony you'll give me the truth, the whole truth, and nothing but the truth?
I do.
Since I don't have it in front of me, I presume from what I heard, the affidavit that, or the complaint that I signed was dated October 18th.
Here you go, just so you have it.
Okay. Yeah, the reason that, that I filed this, I had come across an article in the newspaper, and I followed it up by going to the U.S. Attorney's website. We got a confirmation that Mike Ciaffi, who really is pretty much the owner, controller of the business, had been convicted of tax evasion and went to jail, federal prison, as of October 1st. My past work, I've worked with I've had to review several bankruptcy proceedings. And a common procedure that I noticed was either inventory would be sold and creditors or trade accounts not paid, or on this property I saw a continuing buildup of unprocessed vegetative debris. And I know that landscapers either go to the landfills and pay a vegetative dumping fee, or in this particular case, they were looking at Ciaffi's property as an alternate landfill where they would pay a lower fee. So it was apparent that he was that the property was attracting a good number of landscapers who were very likely looking for a cheaper way to dispose of debris. So putting two and two together with Ciaffi in jail as of October 1st, it looked to me as though it was likely that his family would attempt to operate the business for a while, but mainly build up as much cash as they could and perhaps abandon the property, go bankrupt, leave the property owner with a large amount of debris on the property, which, from my observation and knowledge, can be a source of spontaneous combustion and fire. And we do have wildfire risks in Waxahachie groves that are exacerbated by the fact that we don't have a lot of area covered by fire hydrants. We use the canals. In November is when the dry season starts. We've had a road canal dry. South Florida Water Management is not easy about giving us back-pumping authority to keep the canals as a source of firefighting water. So putting all the pieces together, Ciaffi in jail, his business probably suffering from the fact that he's no longer directly involved in it, seeing an increasing buildup of unprocessed debris that likely fees were paid and people were accumulating cash, seeing that the debris was next to tree areas that could very well be the source of the spreading fire, and making a logical assumption that there was no bond or deposit probably provided to take care of unprocessed debris in the event that the party that was renting the property and accumulating the debris left and just abandoned it. So for those combination of factors and looking at the nature of the operation. It certainly was not an agriculture operation. It was, in fact, a commercial operation, and I knew that land was ag-res. And putting all those factors together, I felt that it was worth, in my own interest, because I live on a road a little further north, filing this complaint and seeking some resolution, either bringing the property into compliance, seeing that there were provisions for a lender that could continue a business operation that would allow him to put up some sort of a deposit in the event that the property was later abandoned, or if it was in violation and couldn't be brought into compliance, that the business cease. So for those reasons, on October 18th, shortly after I was aware that Siafi was now in prison, I filed this complaint. I think two other points that I'm very aware of, because I am one of the members of the ULDC Land Development Code Review Committee, and because I had filed a complaint on October 18th, during the December 4th, 2012 Town Council meeting, I believe, based on the recording, you would see that I was a party that encouraged the Town Council to continue with the investigation of this property on A Road, because the dry season was here. There was apparently no movement of the piles, no significant processing that would mitigate a spontaneous combustion risk. And also, you know, as a related thing, by virtue of the work that I've done on the ULDC committee, there is no grandfathering prior to October 1st, 2006. There is a process where any historic business in existence as of that date can apply for a special exception. And in that process, they do file similar application materials and go before the Town Council and are reviewed as to the nature of the business they conduct, whether they've had complaints from neighbors, and it's up to the Town Council to either permit the operation to continue or to provide conditions under which it can continue. So I do think from several of the comments that have been raised today, I'm in a position to provide some useful background as to why the complaint was filed on October 18th. I mean, it's a simple factor that if the man that was really the organizer and the principal manager operator of the business is in jail for 2 years, that whatever takeover is done by his son or other family members is likely to be disruptive, risky, and capable of going out of business at any time. I think that the Town Council meeting last night came up with an interesting concept. They call it sham nurseries. This is where property owner attempts to put in an agriculture operation to try and get benefit of reduced enforcement of code restrictions, but really has no intent of really making a commercial business out of it, just simply trying to play around with agriculture and ostensibly use some flexibility that may or may not be available if the county approves the operation, which they inspect and you know, make a determination. But this property is still in a state of large-scale debris, vegetative debris accumulation, some processing, and at one time they had a sign that they were selling mulch material, and then that sign went down. So I'm not sure they're doing much more than accumulating material and receiving fees for some future disposal of it in some fashion. So My concern is still there. I think that there are opportunities for the owner of the property working with the renter to bring it into compliance, but I don't see any real progress in doing that. I see basically a lot of dirt being brought in. I think they were spreading it out to make a road ostensibly to facilitate the chipping and mulching operation. And the trees they put in, I think, I have no feeling that they have sufficient trees to make any kind of legitimate commercial business out of it. So I look at it as a sham. And that's why I'm still concerned. That's why I made the comments in the December 4th meeting that I thought the town staff, through the code enforcement complaint that I filed, should pursue this. And if the owner can work with the existing renter or a subsequent renter to bring the property into compliance under the code as a commercial chipping and mulching operation, more power to them. But that isn't happening right now, and that's why I filed a complaint while I'm here.
Let me just ask the town, do you have any questions of Mr. Ryan? Mr. Ryan?
No, I just want to.
Questions?
I just want to ask one. You've known us for a lot of years in the nursery business. We've been in the nursery business for 34 years.
In and out.
In and out?
I said you've been in and out of the nursery business.
No, sir.
Absolutely not.
Well, I'm thinking of Place for Plants. That's the one I'm
Okay.
familiar with.
We never had any relationship with that Place for Plants other than we sold them a few plants and they bought a few plants from us. We never had any relationship with a Place for Plants.
None.
You sold the property to them, right?
No, sir. Not that I know of.
I thought you had the operation on that property originally.
Which property?
Okay, hey, whatever, I don't know that matters too much.
Okay, what I think what's bothering me right now is I thought that we had some kind of a personal relationship with you and at least through FNGLA. And I'm just surprised that you wouldn't have called us and voiced this to us. I'm also surprised you did this in October, and the first complaint that I ever heard of was the day before Thanksgiving. The tree farm is not, it's the office. The tree farm is ours. We had to do a little bit of a rush job to meet the March 1st deadline. Just because his father's in jail does not mean they're going out of business. And if they do, Jerry and I are responsible for cleaning up that property. It's not going to be left to sit there for any, we own the property.
Here's the answer. You had a sign on that property before Siafi moved there for quite a
And
while.
I'll sell anything I have to anybody. But you know what? I need $650,000 for it, and it's not going to come anytime soon.
That's right. You
So
had a sign, somebody take over the payments. It didn't look like you were going to be any owner with an equity.
No.
You know what? You really shouldn't assume things that you hear.
Hold on, let me say this about that whole area. It's really not part of the case.
No.
Whether
Assumptions are not.
whether your guys, your tenant is in jail, or whether or not he may or may not leave debris on the property, that's not what the violation is about. So the complaint may be stemmed from those things. And I understand Mr. Ryan's comments, but that's not what the town's pursuing. The town's pursuing, as I understand it, that there's a commercial chipping and mulching operation on the property, and the zoning isn't proper. So that's what I'm interested. That's the only thing that's going to.
We didn't put the trees in as just some chipping and mulching operation, which it isn't even that. It's a soil amendment operation, and they didn't put the trees in to be able to run their business there. We own the property. We've had a nursery for 34 years. We have never been out of business. As far as the sign that said maybe take over payments,
There's no picture. It was never there.
if it was there, there's a lot, I've been marketing real agricultural land for 20 years. And sometimes you throw a sign up that says this or that to get new opinions, you get new people looking, you get a phone call, And yeah, somebody could have taken over payments, but nobody would at $650,000 for the property. But a lot of assumptions, for you to assume that we've been in and out of the nursery business really hurts
Forget
me
that.
because.
My concern was that property that I filed the complaint on. You had a tenant that I had every reason to believe was very capable of going out of business and leaving a tremendous amount of
Do
debris.
you have
on the property.
expertise to assess someone's business position?
Substantial experience. For several years, I was the section chief for litigation review, reviewing
But
bankruptcies.
you don't
and
know
other
Mike Siapi.
litigation.
You know he's in jail, which we all know. We knew he was going to
Did
jail.
you do
We talked
any,
to the family.
did you
And
look at his?
let me just stop it again here though, because it really doesn't matter to me. That's part of
Yes, but you
it.
gave Mr. Ryan a lot of latitude and leeway to make his opinions.
Yeah, but
They never stopped paying rent.
but whether he's in jail or whether he might.
It doesn't matter if he's in jail.
Exactly. That's my point.
And
So I don't
the
need to
for
hear
sale
about it.
sign doesn't matter. None of this matters.
That's
I
why I
agree.
How long have you lived on A Road, Mr. Ryan?
Since '98.
Okay. Do you remember that property after the year of all the hurricanes? Do you remember what it looked like?
Not specifically. You
We
know,
spent-
my point is, I was explaining why I filed the complaint.
But that was just assumptions on your part, without knowing anything that we know about the Siapis or what our
That-
rents or anything else.
But that was background. I knew that it was a commercial business, that they were operating as a commercial.
Have you ever one single time seen a truck go in there and dump that didn't say Siafi on it?
Oh, yes.
Can you give us names of companies?
Names and pictures,
Well,
because we'd like to have them.
but believe me, you know, these were workers in trucks that were going in and just dumping debris.
Okay, I'm gonna go with your say, just like the town can do.
Okay?
Well,
I'm just telling
Well,
you, so mobile trucks.
That's not hearsay. He's testifying
Well, you
what
can't
he
tell us
saw.
who-
Okay, can you tell us who they were? You're aware of this, you're aware that they're not Siafi. How are you aware they're not Siafi?
How do you know you didn't subcontract out that day?
Well, his trucks do have his name on them.
Subcontracting happens.
Well, okay, trucks were going in, there was a tremendous amount of debris that was being built up. He was operating a commercial operation, it was on ag-res property. It was being done under conditions where I made reasonable assumptions that this property could be abandoned, and reasonable assumptions based on signs that had been on the property for quite a while.
Was there
Reasonable assumptions that it would likely be
Maybe you should
abandoned.
have called us.
Has that happened since you're, I mean,
Not yet.
did you think that was a 1-month process, a 1-year process, a 10-year process?
A very uncertain time process.
You know, you've been a member of FNGLA for a long time, and FNGLA stands by the Florida Right to Farm Act, and stands by each other's nurseries, and stands together and fights together.
There was
And
no
you-
nursery there. There was no nursery. It was a commercial operation.
And you're laughing at the trees we put in.
What makes it a commercial operation, sir?
The fact that it was commercial, that it was chipping and mulching equipment and dumping of vegetative debris and no agriculture operation associated with it. It was just strictly use of land to dump
Soil
vegetative debris
amendment.
and process the vegetative debris, the chipping and mulching operation.
And that makes it a commercial operation?
Yes,
Have you been to Dallas Beach Soil?
Not according to.
under the town code. Under the town code, it does.
Okay, let's get back to the violation or non-violation, but the allegations.
Okay.
Any other questions for Mr. Ryan?
Yeah, did you see the car that was burned on the property the night of our last meeting here?
Actually, I didn't see the car, but when I went home that night, after getting something to eat, I saw several fire trucks and police vehicles, and there were some vehicles parked on the road, and I stopped and got out, and I talked to some of the young people that were there, and I said, you know, what's going on? And they said, well, somebody evidently stole a car and then set it on fire on the property. Now, to me, that was just an additional risk, you know, but it happened.
Do you find that coincidental that it happened the night of our meeting here?
You know, it was curious. It was curious. I have no idea, you
Well,
know.
we are gonna be able to see the pictures. Police have the pictures of where the car was stolen from, and we're going to be able to view them. And they have a clear picture of the person who stole the truck, not necessarily who burned it, but
Well, I was really surprised because usually
Out
the
of
people
nowhere.
there parked a piece of equipment
He-
blocking the
he
entrance.
had the arm of the backhoe up, blocking like he always does, and they drove the car under that to the middle of the lot and burned it.
The kids
Right
I-
up the night of the scene.
Yeah, the kids I spoke to said, you know, this is just vandalism. And I actually talked to a couple of people that have been out here a lot longer than I have. And they said, yeah, that stuff happens. I mean,
Well, we had, our property on Okeechobee Road has had all the copper wire ripped out of the house twice, and the air conditioning was destroyed twice in the last year and a half. And now there's a truck burned on our lot on Hayward. So, you know, we start adding all these things up, and it's just, to me, it's just unbelievable. And I don't even know what the town's aware of or not aware of. It hurts me that we're the church today, because Seth dies on the property, and the town doesn't take any stand about that. And you got a crack house on B Road between Southern and Okeechobee that people are in and out of constantly buying crack.
Well,
And-
let's
but
get back.
you're
let's
coming
get back.
after us for a family who's trying to make a living and a
Okay,
20-year-old
but that-
son, and nobody cares about all this other stuff.
Okay, we
And that
need to
hurts.
get back to this case. So, any more questions for Mr. Ryan? Okay,
Quick, give me a few minutes. Think about it.
I hope next time you'll know that you can call us and we can talk. You can still file your complaint, but
I thought this was an orderly process to bring the property into compliance.
it's going to be done with some of the assumptions.
Did you know we owned the property?
Did I know you owned the property? I found out you owned the property. I didn't know at that time. I think when I filed the complaint, I was told that the entity that owns the property was your entity. But I think before that, I didn't really know that you were the ones that owned it. And the sign that was up there about taking over the payments, I don't believe that was a conventional realtor sign.
Well, I
We
play
only
with
have one
signs.
kind, conventional realty. We only have one kind of sign.
Green and white.
They're all green and white.
No, this was, you know, not that color. I mean, it was a pretty good sized sign that says take over property for
It was a
payments.
4x8 sign on the
We weren't
property
even in a
several
position to
years.
ever let somebody take over payments, so I'm not sure what the deal is with that.
well, again, we need to get back to the violation, or the alleged violation.
You were on the water board for years and may still be. Were you aware that there was a canal on 3 sides of the property?
I know that it's up to the landowners to get the water off their property into the canal, so we have a perimeter ditch on our property. It's not unusual to have perimeter ditches and to
But
have
still-
culverts under the road.
Still, with those ditches, you still thought it was a firehouse?
Spontaneous combustion and a fire going will set trees on fire, whether you got a ditch on the side of the road or not.
Now, how
If it's
close do you
during-
think these piles were to any adjacent tree properties?
Probably 50 feet or so.
Did the car catch any of the trees on fire?
I don't know. I don't even know where the car was. It was out by the time I was there. There was just an awful lot of firemen and police cars there.
Well, it was put right in
None of
the,
the,
called,
so you think some of the piles were closer than 200 feet to the adjacent properties?
I think under the code, it's supposed to be 300 feet from the adjacent property. The adjacent property was wooded, so, 300 feet is,
So you think,
300 feet is a 9-iron shot, and those piles were closer than a 9-iron shot. And oddly enough, just a couple of weeks ago, I helped some neighbors north of North Road put out a fire on their property.
was that Phil's property?
Yeah,
Yeah, I heard that her son's signs were getting burned, and then his mom's property had a couple fires on it. That's kind of interesting too.
yeah, it looked like the fire on that property actually was started at their irrigation control location. I mean, it looked very suspicious.
what, on this property that we're complaining file on. What do you see the end product of all this vegetation that comes there? What do you see as the end product?
Well, I'd actually like to see something that looked like it was moving in and moving out, and not just moving in and being stored there.
Oh, the Florida Right to Farm Act is not going to be stored there, but it is going to be spread there, and it can be taken back out under certain rules and regulations with the Florida Right to Farm Act.
Again,
Well,
you're not,
We're not-
you're not testifying now, you're asking Mr. Ryan questions.
oh, okay, I'm sorry.
Are you aware of under certain conditions, the vegetation can be ground up and taken out?
It made
The
it this way.
vegetation that's generated on the property, can be used, as I understand it, under our code, and that, a property, any property can theoretically be classified as ag property by the property appraiser, and then, it can either qualify or not qualify under the Florida Right to Farm Act, under best management practices and other things. But a chipping and mulching operation, as it exists now, is a commercial operation. It's not ag and it's not right to farm. And that's speculative, that's really speculative.
Well, that's not what the state attorney in Tallahassee says about the Florida Right to Farm Act.
From the definitions you heard before on chipping and mulching, not being an expert, but just being a layman, would you say that if the end product is soil and not mulch, the operation that's being conducted there is defined by this chipping and mulching, or is not defined by this chipping and mulching?
Well, from what I've seen, there's a lot of unprocessed vegetative material, and the material that's been processed, I presume, is the result of grinding up that vegetative material. That's what I see.
Yeah, there's nothing that I can find here about how long something can sit there, only how it ends up. So if the materials that are coming to the property from off-site are ending up as soil, and the definition that we heard before is of chipping and mulching is the end product is mulch. Are soil and mulch the same thing?
I don't look at them the same thing.
Okay. Would you agree that an operation that ends up with soil is not defined by chipping and mulching and ending up with mulch?
I would presume over a very extended period of time, you can have almost anything go back to soil. But, initially, you're processing it, and it's just vegetative debris that's ground up.
Are you aware that there was 2 or 3 times, Jerry may be able to tell me exactly how many, that Nick called us and people had illegally dumped out right by a road, and rather than call the police or have a problem, Nick brought his equipment out, took the illegal dumped items to the back for the A road residents to be able to get around it?
I wasn't aware of anything specifically like that, but I know that happens on several properties out here in the groves. People dump material.
The materials that you saw coming in that you thought were not Siafi's trucks, did you ever once see any other name or just blank trucks?
But when I saw them, they were actually inside the road, off of a road. So, I wasn't paying attention to, taking
They
down
just want
people's
red.
I know his trailers are all red,
Yeah, that
fire engine red,
Yeah.
but I believe his trucks are, I believe they're all white. I believe some of them are marked and some of them are not marked. But did you see any from any other company that you were aware of?
I just saw, trucks that weren't red. That's about all I knew, was that a lot of debris was being brought in.
Okay. I don't think I have any more questions.
Okay. You're all set.
All
Thank
set.
you. I think it's your turn.
Should the town go first end up? I guess we end up first.
Well,
I feel like we're at a ball game.
Well, the
What inning are we in?
the town went first. They presented their case, and you have a chance to present what you want to present.
I think we have as we've gone along because we didn't really know the procedure. We just feel like every time we have contact with the town, they're changing the rules, they're making the rules tougher. They're going from 5 acres to 10 acres, they're going from, we didn't submit an application to, oh, we let you go for a year without an application, even though we knew you were there and doing this, or we didn't react because there wasn't a complaint. We're told that we're addressing a complaint from a fish farmer next door. We've seen none of that here. Instead, we find out we're addressing a complaint from Mr. Ryan. We have people calling us, telling us that the town has it in for us. They heard a conversation. The town could have, should have let us know before we got to this point that we could have gone for the special exception or whatever and been grandfathered in at the other property. And it seems like we've got, even though Russ came out and said, we want to work with you, we don't see it. We see, we want you out of here.
Well, let me ask you a few questions just so I understand. How much property is there?
10 acres.
And did I just hear that 5 acres is being converted to a tree farm?
Yes.
Now, are you planning on keeping I won't characterize it, but the current operation on the other 5 acres?
Yes, there's a pond dug actually in the back to irrigate the tree farm. All irrigation isn't in yet, but we want to get the trees planted by March 1st.
We feel that by definition, that can be done by the Florida right to farm.
What can be done?
You can have a tree farm on the property and grind
They
vegetation.
call it a compost facility to get the soil to amend the tree farm.
Okay, I'm not going to say whether you're right or not because I don't know. But that's not why we're here today, I don't think. I mean, that's a different case.
Well,
I mean,
it is why we're here today, because at this point, we've stopped.
The reason we're presenting this information is the town says we want to work with you. We don't believe it. We haven't seen one thing other than fill out this application, give us $5,000. There's no guarantees. That's how they want to. We can't afford $5,000. We see that as just another, hey, we're dotting our I's and crossing our T's, but we're going to throw it out. Otherwise, we feel they would have told us on the other property, hey, you could stay here, you could get a special exception, you could be grandfathered in if you follow these rules. Then the next contact we have with them, you need 5 acres. But now, through some explanation there today, which I didn't follow, I mean, it says right here, September 27th, 2010, 5 acres, but somehow they
Well,
went through
the
all these.
explanation was that the county code was 5 acres at the time. The town had not adopted its ULDC at the time, and when the town adopted its code, it was 10 acres. Is that correct? So you got caught right, that letter was written right before the code changed. Now the question being, how long has your operation been on this property?
A little over a year. We started moving there in December.
Okay.
And the reason we ended there is because we were forced off the 5 acre property. Ms. Toot doesn't want to say we were forced off, we were in violation. But had the town made us aware of this October 1st, 2006, we could have got a special exception there. But we tried to cooperate with the town.
Okay, so I'm gonna let you do that, but let me just make sure I see where we're heading here. Your contention is that you're going to do and I'll use the term legitimate, but a bona fide commercial tree farm on 5 acres, and you would like to, I'll use your terms, produce soil on the other 5 acres that would be used at the tree farm. Okay. And your position would be that would comply with town codes.
No, sir.
No, I'd like to read you, I can read
Okay,
you.
you acknowledge that?
Well, it might if they'll let it, but I'm gonna have the code for a
We're
tree
not
farm.
gonna pay $5,000, so it'll never come to that point.
Well, I don't know whether that complies with town codes or not, and I don't know whether you would need any kind of approvals from the town to do that, or whether your town is okay to do that. But where I'm trying to head is this, I mean, if you're sort of saying that, given our new operation, we're gonna be complying with the town code?
No, sir.
Okay, you're not saying that?
No, sir. We're saying that,
We'll be complying with the Florida right to farm.
we were saying that we try to work with the town. The town tells us they want to work with us. They make it tougher and tougher. We can't work with the town. We can't pay $5,000. It was never mentioned until recently, $5,000. We cannot pay it. So we're going to work with the state of Florida, which I believe will probably override
I can read something, if you'll let me just read this.
the town of
It
Loxahatchee.
clearly states that.
Sure.
I highlighted a few things here. This is the Florida Right to Farm Act. Legislature further finds that agricultural activities conducted on farmland and urbanizing areas are potentially subject to lawsuits based on the theory of nuisance, and that these suits encourage and even force premature removal of the farmland from the agricultural use. It is the purpose of this act to protect reasonable agricultural activities conducted on farmland from nuisance suits. Farm means the land, buildings, support facilities, machinery, and other apprentices used in the production of farm or aquaculture products. Farm operation means all conditions or activities by the owner, leasee, agent, independent contractor, and supplier which occur on a farm in connection with the production of farm products, which includes but not limited to the marketing of produce at roadside stands or farm markets, the operation of machinery, irrigation pumps, the generation of noise, odors, dust, fumes, ground or aerial seeding and spraying, the application of chemicals, fertilizers, conditioners, insecticides, pesticides, herbicides, and the employment of labor. Going to jump down to another section.
What are you, I know you're reading from the Right to Farm Act, but where are you reading?
823.14.
Mr. Magistrate, I have a copy of it where it was somewhat better than that's.
I read exactly what's.
I have a.
Okay, I'm going to go to B. The farm operation shall become a public or private nuisance as a result of the change in ownership, change of type of farm product being produced, change in conditions or around the locality of the farm, the change brought about to comply with the best management practices. We haven't done that. We've been doing the same thing all along. The most important, 487.05. A local government may not adopt any ordinance, regulation, rule, or policy to prohibit, restrict, regulate, or otherwise limit an activity of a bona fide farm operation on land classified as agricultural land pursuant to 193.461, where such activity is regulated through implemented best management practices or interim measures developed by the development of the environmental protection. The health department came out to the 162nd Street site. They saw the same equipment. I asked the health inspector if there was any kind of a nuisance or any kind of a complaint there that should be done at all against the Florida Right to Farm Act. The only problem we had there was we did not have an ag exemption. His exact words to the machinery that is still being used by this leasing of ours was, "Oh, hell no." Those were his exact words.
What was on the property before your current operation?
The 10-acre property,
Yeah.
it was cleared.
You cleared it.
At a cost of
What was
over
it?
$100,000.
Was cleared,
It was a fish farm.
No,
Wasn't
years
it?
and
Like
years and
holes.
years ago, when we bought the property, it was a fish farm with giant holes in the ground and Florida hollies growing out of them, and
when did you?
5,000
We bought it
60
down
to
by,
80 foot tall
Right, so about
Australian pines.
Hurricane time is what you're talking about.
That
Okay.
most of them were like pickup sticks.
So you
we spent
spent
$100,000 to clear it
over
level.
So you cleared the land for between, or post-hurricanes, we'll say, and then when did this operation commence?
Well, when we had to move him from 162nd Street, that he was already on 162nd Street in probably 2004 with his partner who had the lease, and then we wrote the lease with him in 2006. This operation has been there since late November of last year was when he got his machines over there, late November, early December.
Of 12 or 11, 2011?
11.
Let me ask the town, the Attorney General's opinion that has been obtained, does it apply to any of this?
No, it's only
No,
the
it
Attorney General's
relates,
opinion
it
of
relates,
buildings.
it relates to the
structures,
regulation of the structures, size,
Fences,
yeah, farm permits as it relates to
Right.
setbacks.
Your Honor, before we had a tree farm there, I understand that their complaint may have been valid. But we had planned on, we actually had asked them if we could put a tree farm on 162nd and get the ag exemption before they told us, no, you have to be on 10 acres. I had already applied for the ag exemption on 162nd Street. The ag exemption people remembered me this year and asked me to please write a cover letter explaining why the trees were being put in as late as they are this year, and I explained the situation out here, that once again, we now have another complaint we're trying to get. But we did manage to get the tree farm in, and yes, it is not pretty, but the trees will grow. They're foxtail palms. They're not trash palms that we just grabbed from somewhere. They sell for $2 a piece in a 1-gallon pot. And we probably have several hundred more.
Anything else you want to tell me? Any questions?
Yes, sir. If I understand correctly, and based upon the photographs that we were able to take yesterday, the equipment, the chipping and mulching equipment and the chipping and mulching operation is still occurring on your site?
No,
Soil amendment is on our site for our tree farm.
we're not
Can you explain to me,
We're not manufacturing. mulch.
DC is not manufactured.
can you explain to me what the definition of soil amendment is?
It's not mulch.
Can you explain to me the definition of soil amendment and the differences?
Yes, it's adding soil that's been processed from vegetation, that's got nutrients in it, being added. Just like the hundreds of thousands of loads of manure that's come to Loxahatchee in the last 10 years, the dumping ground of Wellington. That's how they get away with it, as soil amendment.
Would you agree that soil amendment could be described as non-living organic material customarily used in landscape design to retard erosion, retain moisture, and control weeds?
It's too technical for me to make a comment.
Well, let me ask you again. In the process of soil amendment, are you utilizing non-living organic material?
Non-living organic material, I believe that's correct.
Is soil amendment used in the production of a landscape material that would typically retard erosion?
We're only using it for a tree farm. You're asking us questions that
For
are
what?
out of our realm of knowledge.
For what purposes would you use the amendment? Would the soil amendment be used to, as part of
There's
a
nutrients in
technique or
it.
tool or a nutrient? Does it retard erosion, retain moisture, or control weeds?
It might do any or none of those.
But possibly it could.
It may or it may not.
Okay.
Gee, are you against us or are you trying to help us? Let me ask you that. I have some email here from Carol Foreman.
Ma'am, it's my turn, so.
Oh, sorry, go ahead.
Okay.
I just feel like we're under attack again like we usually are, but go ahead.
Your Honor, the Loxahatchee Groves Land Development Code does not have a definition per se for soil amendment. I will make that clear and put that on the record because I know at some point it probably will be looked into. However, I do have a description, a definition of mulch, and as Mr. Hastings has indicated, The process of soil amendment could be related to non-living or organic material customarily used in landscaping design to retard erosion, retain moisture, and control weeds. As defined in the Loxahatchee Groves Land Development Regulations, that is the definition of mulch. And I may now submit this as exhibit
On 6.
number 6.
Would it be possible for you to look under Wikipedia there and read us a definition of mulch and a definition of soil?
I've got here some information, and certainly I can make this available to you. Soil amendments improve the physical, this comes from, and again, we'll respond to you, see if we can find another. If I may respond, this is from Colorado State University Extension Office. It's just the first one that we happen to come across when I ask for us to take a look for it. Soil amendments improve the physical properties of soils. Amendments are mixed into the soils. Mulches are placed on the soil surface. The best soil amendments, which again, this definition coincides with the definition of mulch. The best soil amendments increase water and nutrient holding capacity and improve aeration and water infiltration. The soil amendment is material added to a soil to improve its physical properties, such as, again, water retention, permeability, water infiltration, drainage, aeration, and structure. Again, pretty much the same definition as defined in the Unified Land Development Code for mulch. So what I'll do is I've marked on these, but if I may, I'll submit them.
Do you have the definition of,
I believe if you go to Home Depot, you'll get a good definition of mulch and soil.
of chipping and mulching? Do you have that there as well?
Can you go back to
From the code.
Can you go back to chipping and mulching operation?
And the definition you're giving me of mulch is from the code, town's code.
Yes, sir. Number 6. And would you like to move some of these exhibits on?
Yeah. We'll do that. So exhibit 6 will be definitions from the town code.
Yes.
Including the definition of mulch.
May I just see forward on my question?
Sure.
Can you tell me, in the process of producing a soil amendment, would it be fair to say that in the process of soil amendment that you're using the same equipment and that at some point in the process it is a chipping and mulching operation?
By your definitions, no.
Can you explain?
We are using the same equipment, or the renter's using the same equipment. By your definition, what is. By your definition, we're not making
Do
mulch.
those machines chip and grind a material
No.
brought from
Well, you
outside?
broke grind. We have a grinder. We do not have a chipping and mulching machine. We have a
You
grinder.
have a grinder.
Yeah, just like one of your town councilman's son has.
Thank you. And in the process of that, what is the final product that comes out of that?
Soil.
But in the process of creating that, is there at any point where it is a chipped or mulched product?
There is a process that takes a big particle from a palm frond to a palm stump, and at some point, it makes it all sizes of particles until it's a soil.
That's correct.
Very small, granular, beach sand sized particles.
I think this is the answer here. This is from Carol Foreman.
Ma'am.
I'm answering your question,
Okay.
okay? I don't believe that we have a chipping and mulching operation. I believe what we have, according to the Florida Right to Farm Act, is a composting operation. And yes, they use the same equipment. If it appears the composting operation would qualify as being part of the farm, compost is used on site to grow the nursery plants. The use of the compost, where the material is brought in from off-site, processed, and then taken off-site, it's difficult to question the answer if they're taking it off-site. That could need a more detailed analysis than she could give me with the facts that I gave her. If, however, the site meets the requirements, which are a bona fide farm operation and classified through the county, then we have a case for the exemption. It's a composting operation that we have. We are composting vegetation and making soil. Do you use the exact same equipment? I don't know. I don't think the big red machine that brings the soil down is on a chipping and mulching operation. I could be wrong, but I don't know about that. What we have is a compost operation according to the Carol Foreman from the Florida Right to Farm Act. We bring in vegetation, we grind it up, we stack it, we wait for time, it becomes soil, we spread it, we use it for soil amendment. It's compost, it uses the same machinery, it's not chipping and mulching, it's a grinder.
Do you see any similarity in our thing and our product here and the manure that comes in?
We don't bring-
respond to that. I'm directing questions to you now. So,
And before you ask the next question, just so the record's clear, I'm going to mark as Exhibit 7, Town's Exhibit 7, the Colorado State University article on soil amendment. So we'll have that as part of the record.
but I think what I'm hearing is you're not denying the fact that at some point in that operation, there could be a product that would come out of that grinder that could be considered chipping and mulching. That what you're saying is that you're reducing the chipping and mulching down to something.
We're making soil, we're not
into a
making
soil.
mulch.
But at some point in that operation, I mean,
Okay,
you're using the.
well, if you're making mulch to sell it at Home Depot or the mulch bags, you have chips of chunks of mulch. You do not have that on our property. It is, I don't believe any of the piles are gonna be chips of mulch because all the green vegetation is also mixed in. They're not just grinding up wood pallets, and wood, whatever they bring in from wood, like the F-Road guy. Does he have vegetation? No. he's-
Construction debris. There's no
Construction debris. There's no construction debris on our site. It's all vegetation debris. It's composting. It's not chipping and mulching.
What do you do with that final product? Regardless of
Well,
what you call it?
we're trying to get enough.
What do you do with it now? What have you been doing with
We
it?
put a berm out front. We use it to spread and get area for the tree farm. We are planning to help the neighbors out to put berms up the side. I don't have enough of it now because it has to be made into soil to be able to do that.
Okay, listen to my question. What this final product, whether you want to call it chipping and mulching, or you want to call it soil amendment, over the last year, since you have moved to that property, and since we have issued you a notice of violation, what was the purpose for that final product?
it
Whatever
takes-
you want to call it.
It takes 6 months to a year for the compost to become soil. So it has to.
The answer is, we don't know, you'd have to ask Mr. C.
But it does take 6 months to a year for it to compost down.
I think I'm finished with my line of questions, and I would just like to finish with a brief.
Yeah, do we have that definition for?
Yes. Chipping and mulching, use of equipment designed to cut tree limbs, brush, or wood construction debris into small pieces, including the production and wholesale of mulch for land application. This is from the Waxahachie Erosion and Redland Development.
That would be 8.
Could you read it again, please?
Yes, sir, I would be happy to. Chipping and mulching, the use of equipment designed to cut tree limbs, brush, or wood construction debris into small pieces, including the production and wholesale of mulch for land application.
And just cut it into small pieces.
I
That's,
believe-
that's the end product, small pieces.
But that's Waxahachie Grove.
It doesn't matter.
Well, it does matter.
No,
because the
small
farmer-
pieces is not soil. By
I-
definition, it's not the same thing. By
Okay.
definition, it's not the same.
You're correct. The Florida Right to Farm Act says a local government may not adopt ordinance, regulations, rules, or policy to prohibit, restrict, regulate, or otherwise limit the activity of a bona fide farm operation on land classified, and on and on and on. Your laws do not trump the state.
Your Honor, I am prepared for my final.
Okay, why don't we do that? We'll have a brief final statements. And
Okay,
then
brief final statement. We are going to move forward and to request that you issue an order of violation. Again, I would refer you back to the definition of mulch in the Unified Land Developments Code, and how it pertains to, correlates with a soil amendment process, that it could be defined as a portion of that process. I will also refer you back to Mr. Hastings' statement when I asked him about the definition of mulch. And he did indicate that yes, it could be actually described as a soil amendment process as well. So I'm suggesting to you, Mr. Magistrate, that it's used one and the same for the town of Waxahachie Groves. The only exception to section 80-055 for commercial chipping and mulching operations is that the regulations would not apply to the occasional chipping and mulching of wood materials generated on site, which in this case they are not, and associated with property maintenance or any bona fide agricultural use, which I understand that could become a bona fide agricultural use, but up to this point it is not, and conforming to generally accepted agricultural and best management practices, which indicates that even if you were to move forward with a commercial nursery operation, there would have to be best management practices put into place for any type of occasional chipping and mulching operation. So with that, Mr. Magistrate, I close and stand for any additional comments you may have.
Okay, any final comments you'd like to make?
Yes. I believe she put words in my mouth as to my comment about mulch. She asked me 3 times if that could be considered mulch. 3 times I said that may or may not be. So that essentially was, I don't know, not yes. It was essentially, I'm not answering your question, I'm being as vague as you've been, because I don't know 100% whether it is, 100% whether it isn't, or 15%. I don't know the answer, and she made my answer positive. That it was not the case at all. And we are not ending up with mulch. Your definition for the 5th or 6th time is small wood pieces. We're not ending up with small wood pieces. We're ending up with soil. I don't see it as any different than the manure that you allow to come here.
And there's something else that you asked what we would do with the soil. We have 2 other nursery locations. We have one in Delray Beach and we have one on Seminole Pratt Whitney Road. And we are permitted under the Florida Range Farm Act to take our soil that's being generated on our property and use it in our nurseries. Right now, we purchase it from Atlas Feed and Soil. When there's enough there, we can take a truck and we can take it to our nurseries and we can pot up plants with it. And we have 2 locations.
Okay. Interesting questions and issues. I am going to find that the operation, at least up to the current time, was in violation of the town code. And so I will find a violation. What I'm not finding and not ruling on at this point anyhow is whether your converted operation complies with the town code. And because, you know, code enforcement is that, my finding is that a commercial chipping and mulching operation violates the code. I do think, and I'll clarify this, and I'll end up putting this in writing, I do think the definition of chipping and mulching, I know Mr. Harrison's going to disagree with me.
It's Hastings, sir.
I'm sorry. I think it does meet that definition. Use of equipment designed to cut tree limbs, brush, and wood into small pieces. I think that happens as part of the process, and it says it does not have to end up in mulch. It says including the production also of mulch for land application, but it's not exclusively that. I think the operation, as it has been going on, is a mulching, at least a partially a mulching operation that may end up in soils. I understand you may continue that operation until you end up with soils. So I am going to find the violation. As I said, I'm not finding that what you're converting to does not meet the code because I don't know. And I'm not finding that what you're converting to may be permitted by the Right to Farm Act. I think that's up to the town to make those determinations as to whether or not you will be in compliance based upon what you're going to do with the property or have converted the property to. Because the point is that if it's a violation, you need to comply. You can comply by doing nothing. You can comply maybe by meeting the town code and not running a commercial chipping and mulching operation on the property. So I can't prejudge that. What would happen though, and what I'm going to do is give 30 days to comply. And by that, I think it's time for you folks to get together with the town to demonstrate to the town what you're doing, and they will administratively make a determination on whether or not that complies with the town code. If they say it does, you know, all's well. If they say it does not and you disagree, you would have a right to come back here to me to present whether or not you comply with the code. And I think at that point we can get a little more into the Right to Farm Act. And you know, I'm not sure at all about the dates. I mean, I know when you said you started operating a year ago, you know, I don't know how those dates factor into whether the act applies or not. I don't know.
Well, we were there for more than a year, and if a farm is on a piece of property for a year, a nuisance complaint cannot shut down the farm.
Okay, but I would suggest to you this isn't a nuisance complaint.
Well, it was because it all came about. They don't act on anything until they get a complaint.
Well, I don't. It's not the time to debate whether you meet that or not. It's something that you address. But
I believe that in itself is an error, because I believe if we asked Mr. Ryan, was it a nuisance complaint?
the complaint I've heard is not a nuisance complaint. I'm sure there's a nuisance provision in the town code that says if you have a nuisance, you got to stop it. And that's not what they've said. They've cited you for running a chipping and mulching commercial operation.
The rules change every time we come in here. Mr. Ryan started as a nuisance complaint. It doesn't end up as a nuisance complaint because it works in the town.
And we weren't even called until the guy next door called because of the nuisance of the noise the day before Thanksgiving. And Mr. Ryan filed his complaint in October, and nobody ever told us about that complaint until today.
We're treated differently than
Okay,
everybody.
my point being, I'm not
Okay,
preaching.
so where do we end up here? Because I know what's the town is not going to agree with us. We already know that. 30 days, I can get information from the Florida Right to Farm Act. I can get pictures to them. I can get statements from them, from attorneys with the Florida Right to Farm Act, and then we'll be back here in 30 days because they're not going to go along with us. And they do not trump the state. The local government may not adopt and do what they're doing
Okay.
with what our process
And again,
is now.
I'm not going to prejudge that, but there's a lot of issues. I mean, one issue is the code was in place, and then you put your operation on the property.
But I filled out the application.
No, I'm just telling you,
They moved us there. They moved us
there's
there.
issues.
The reason,
There's
sir,
issues.
that we're doing it this way is because the town states, we want to work with you. We do not see that. We see the town making it tough. We see the town telling us that all the ag cases are on hold. And then except due to the December 4th meeting, go ahead with their complaint. It's not in the December 4th meeting. So then, oh, well, that's not literal. That's just,
Okay.
it happened. Take our word for it. It happened.
And
We
what
have
else?
to prove everything. But you won't take our word for anything, but we produced the minutes. It didn't happen. Oh, yeah, it happened. It's not literal.
So that'll be my ruling. What we want to do, when is the May meeting? Do we have a date? The May.
Would it be the 30 days, would it be the April?
Well, we wouldn't be, would it be before the April meeting? It might be. Yeah, it would be. Yeah, we could do it April.
And,
I'm going to be out of town for the first 2 weeks in April.
and Mr. Magistrate, I'm glad you brought that up because we're usually the third Wednesday of the month, and I wanted to request that maybe we could move it to the fourth Wednesday, I believe is what I mentioned to you. the fourth Wednesday of April.
That would be April, the date, 24? You'll be back in town?
Mhm.
Yeah, and I will be too.
Okay.
So essentially, that will provide them with an additional week.
So
Okay.
what do you want us to do with you, since you continually say you want to work with us?
Well,
You know what's happening
Fill out
there
the
now.
application to give them $5,000
Well, we're
and no
not, we
guarantee.
can't,
Let-
there's no, we can't do
let me
that.
just finalize my ruling, and we can even talk about that, but I will give then until April 20th to comply. Why don't we say that?
But we're not gonna have the $5,000 to do their application by April 20th. We can tell you right now that we don't have the money to get the engineer to survey.
Well, I don't know that you need to apply for anything. I don't know what you need to do.
Okay, well, according to the application, that's what we need to do.
I'm not,
I think that I'm gonna be able to.
Yeah, I don't know that you need to apply. You may not need to change the zoning, depending on what you're doing. That's my point.
I think this can be found as a compost operation, but I need to research that more.
Well, it could be, but, and the issue will be whether what you're going to be doing at the property, and are doing at the property, constitutes a chipping and mulching operation, which, at least in my opinion, is a problem, or whether it's something else that's permissible under the code. If it's permissible under the code and you don't need to amend the code, your zoning or rezone, you don't need an application. So what would happen at the April 24th meeting is if the town agrees before then, say by April 20th, that you meet the code by what you're doing, then you're in compliance and we're done. You don't have to come back. If the town says, no, you're still in violation of the town code, then we would have a fine certification hearing, a fine assessment hearing, and you could argue that, no, we've complied. Okay. Question? Does that make sense as far as how to approach it?
I missed the last part, but I believe so.
Yeah, I'm just saying, if there's a disagreement about whether they've complied with the code, then they can come back in and have it heard. I mean, that's really the issue with whether a fine's assessed or not.
Well, let me just, as a point of clarification, we're taking action, I mean, the action that we're taking today is based upon the use that you've already found to be in violation.
Mm-hmm.
So, would it not be, I mean, so now we're talking about two different things. We're talking about a use that they have, they want to convert to a different use. I would suggest that they get with the town as soon as possible to talk to the town about the conversion of that use.
We
What I would
never
suggest
had
is-
use in the first place. Why would we, we're not converting to anything. We put in a tree farm. You guys know that, wouldn't we?
When did the tree farm go in?
It was planted by, I think, the 28th, the 27th February.
Okay, well, it's a week ago.
I know, I
So,
know.
okay,
And
well,
it was a lot of pressure to get it in by
We're
March 1st.
trying to follow the rules to get an ag exemption.
Yeah, no, you need to do it by March 1.
Right.
I understand
And it
that.
will look a little prettier had we had more time, so now we've got to pretty it up a little bit.
So would we not, Mr. Magistrate, based upon the order of violation, the existing violation of the commercial shipping and mulching operation, that they either need compliance somehow in the 30 days, or they remove that operation from the facility, or at that point in time, we bring them back to fine certification. But in the meantime, if they do find that, and it is found through cooperation with the town and town staff, that this is a conversion and that they are planting a tree farm there, and they are going to have an accessory type of chipping and mulching operation or soil amendment operation that would be in compliance with the land development regulations, that if they needed a little more than 30 days to come into compliance, we could extend them to 30 days.
Okay. Yeah, I don't disagree with any of that. I think the point being, if the operation stays as is in the sense of a chipping and mulching operation, and that's what I hear on April 24th, then you haven't complied. If you've ceased that operation by converting it, by removing it, then you comply with the code and you don't have a fine issue.
We said that we did that a week ago.
Well, maybe you did, maybe you didn't. but
We complied with the Florida Right to Farm Act told us we had to do in order to be under the Florida Right to Farm Act.
well, then you need to convince the town that,
Correct.
that,
Town's not convinced, they went and took pictures yesterday and said no.
okay. You need to
So-
convince the town, and if they disagree, then you need to convince me.
Correct.
Is there a possibility we can convince you if we can't convince the town?
That's what he just said.
That's
You
what
would
I
No,
said.
I'm
back in
asking,
front of the
I'm
magistrate.
curious how many cases, I mean, you know.
Well, you need to present your case to
We
me.
didn't seem to convince anybody today that we've been treated differently and unfairly. So we're.
We'll wait for the next fire tonight, you know?
We think it's a stretch that we're going to convince anybody in this room of anything.
Well, let me just say, I mean, I know we're getting quick to close here, but I don't typically go out on a site with an application and stand and talk to you.
No, I thought it was all done, I thought we were
Excuse me.
good.
And I don't typically say, you know, you might be able to get by putting in a here, and justifying that you don't need to do this, because that's not my job here in the town. So I did actually go out of my way to try to help you. And quite frankly, I have to say that I was a little bit surprised that the application, I mean, you know, I heard the whole story about the submission to Steve, but then there was still plenty of opportunity when you found out that Steve hadn't routed it, it got lost, whatever.
We
You
gave Russ,
still-
when Jerry met Russ, he gave him another copy. We've given the town 3 copies of what you and I did on the lot that day. Do you know how frustrating that is? But now the rules have
But
changed.
clarification, you're
Correct.
given an application, but you're telling the magistrate you're not gonna pay the 5,000, so
Correct.
technically you're not doing the application,
Correct.
because you're refusing to do it.
Correct.
You can hand us the paper
Refuse.
25 times.
You know what?
If you don't go through with the rest of it,
You know what? All you want is money out of anybody, you can suck it out of
It's
here.
not just Mrs. Hastings, it's not just the town of Loxahatchee Groves, that's the process in every community that you probably are doing business.
You know, we talked to a few attorneys to see if they would help us with this. And they said, well, you can't pay us very much. We think we could win the case. We think we could sue the town, but they certainly can't pay us very much. They have no money. And
I think we're getting beyond things
we
here.
we know that because of a case that's going on. Now, I don't know what case that is, but somebody seems to know that.
I will enter an order, if you get a copy of it, and it will ask you to comply by the 20th of April, and that if you comply, fine. If you don't, you can come back on the 24th and
What exactly do I have to do to comply? Other than pay $5,000 and fill out a chipping and mulching application?
see, you're not listening to me.
Yes.
You're not listening to me. You
Go
may-
talk to them.
You
Go
may
talk.
not need an application, I don't know, I'm not a town planner, I'm not the town administrator.
They've offered no other alternative, sir.
Well, maybe they're going to now.
Well, maybe they didn't know until 7 days ago that you had a tree farm in there.
Correct.
We told them it was coming, but, you know, everything takes time. and
Okay.
money.
Well, let's adjourn on that note and go from there.
Thank you.
Let me get your number again. Obviously, we need to talk to somebody, I'd rather you get away from the town
Oh,
office.
well, no, I tell you what, I'm gonna give you my number.
If I'm in the town office, everybody hears me.
Well, you're not gonna be able to come to my office, I'm not the town planner.
Okay. Well,
I can give you some
so now
guidance.
you're the town planner?
You're gonna need to see if you can make arrangements, you're gonna